Chapter VI, Subsequent Creditors, SS 96, Fraud upon Subsequent Creditors. The great practical distinction between existing or antecedent creditors and subsequent creditors in most of the states is that a voluntary alienation is considered, as to the former, presumptively fraudulent, while as to the latter the burden of proving an intention to commit a fraud, or the existence of a secret trust or reservation, rests upon the creditor. Generally speaking, subsequent creditors must elicit facts showing contemplation of future indebtedness by the insolvent. Voluntary deeds, it should be remembered, are ordinarily invalid only at the suit of antecedent creditors, and the absence of evidence showing fraud in the transaction will usually defeat the actions of subsequent creditors. As we shall presently see, there is no presumption to aid the latter class. A specific intent to defraud subsequent creditors will manifestly avoid the transfer as to them. In the absence of proof of such an intent, the transaction will stand. Chancellor Kent, in his celebrated judgment pronounced in Reed v. Livingston, a case already noticed, said the cases seem to agree that the subsequent creditors are let in only in particular cases, as where the settlement was made in contemplation of future debts, or where it is requisite to interfere and set aside the settlement in favor of the prior creditor. Judge Story observed, where the settlement is set aside as an intentional fraud upon creditors, there is strong reason for holding it so as to subsequent creditors, and to let them into the full benefit of the property. In Savage v. Murphy, it appeared that the judgment debtor was engaged in an extensive business on credit, in which he was considerably indebted, and that he stripped himself of the title to all his property by transfer to his wife and children for a merely nominal pecuniary consideration, without any visible change of possession, and with the intent to contract and continue a future indebtedness in his business on the credit of his apparent ownership of the property transferred, and to avoid payment of his debts. After the transfer, he continued in business, making new purchases on credit, and using part of the avails of each successive purchase to pay the indebtedness then existing, during a period of about 10 months, at the end of which time he failed, owing debts thus contracted amounting to $3,500. The court, upon these facts, held that it was clear that the transfer thus made was fraudulent and void as against subsequent creditors. The design to obtain a credit after the conveyance by means of the continued possession and apparent ownership of the property, which the debtor thus placed beyond the reach of those who might give him future credit, was plainly fraudulent. The conclusion of fraud was not repelled by the circumstance that the debts owing by him at the time of the transfer were paid with the proceeds of credit subsequently acquired by the means already stated. The indebtedness then existing was merely transferred, not paid, and the fraud was as palpable as it would have been if the debts remaining unpaid were owing to the same creditors to whom he was obligated at the time of the transfers. SS 97, it may be here observed that a fraudulent and deceitful conveyance of property, made without valuable consideration, and with intent to injure the rights or avoid the debts of any other person, is invalid as to subsequent creditors as well as to those who were creditors at the time of the conveyance. In Parkman v. Welch, Dewey, J., in speaking of the rights of subsequent creditors, said, "This raises the question whether the effect of the statute of 13 is. C5 is to avoid conveyances made upon secret trust and with fraudulent intent, as well in favor of subsequent as previous creditors. On this subject we apprehend the law is well settled, that a conveyance fraudulent at the time of making it might be avoided in favor of subsequent creditors. In Tony v. Majehi, the rule is recognized that a voluntary conveyance may be impeached by a subsequent creditor on the ground that it was made in fraud of existing creditors. But, to be successful, the subsequent creditor must show either that actual fraud was intended, or that there were debts still outstanding, which the grantor owed at the time it was made." SS 98, Proof of Intent. The subject of the intent of the parties to an alleged fraudulent transfer will be considered presently. Speaking of the sufficiency of the evidence of the intent to defraud subsequent creditors, Johnson, J., said, upon the question of fraudulent intent, or whether the conveyance is fraudulent in fact, as to subsequent creditors, it is proper to consider the circumstances of its being voluntary, and the party indebted at the time, and if additional circumstances connected with those two be sufficient to show fraud in fact, it is void as to subsequent creditors. It is not necessary that there should be direct proof to show the fraud. It is to be legally inferred from the facts and circumstances of the case. Where those facts and circumstances are of such a character as to lead a reasonable man to the conclusion that the conveyance was made with intent to hinder, delay, or defraud existing or future creditors. Folger, J., delivering the opinion of the New York Court of Appeals in Shan v. Hanley, observes upon this subject that there is no difference in result, as there is no difference in the intention to produce the result, between a transfer of property to defraud a creditor existing at the time, and a creditor thereafter to be made. A conveyance intended to defraud creditors is voidable not only as to existing but as to future creditors. The intent must be mutual. Marriage, as we shall elsewhere see, is a valuable consideration which is much respected in the law, and an antenuptial settlement, though made by the settler with the design of defrauding his creditors, will not be annulled in the absence of the clearest proof of participation in the fraud on the part of the wife. SS 99. Conveyance by embarrassed debtor. In Wallace v. Penfield, it appeared that the debtor, who was somewhat indebted at the time, made a voluntary settlement upon his wife, by causing the title to the lands in question to be taken in her name, with the intention of immediately building upon and improving the land and using it as a permanent residence for himself and family. It was shown by a preponderance of evidence that when the settlement was effected, and during the period the land was being built upon and improved, the debtor had property which creditors could have reached, exceeding in value his indebtedness by several $1,000s, and was engaged in an active business with fair prospects. All the creditors whose claims existed at the date of the settlement, or during the period when the debtor was making expenditures for improvements, had been fully paid and discharged. The plaintiff's claim accrued subsequently. The Supreme Court of the United States very properly decided that these facts were entirely consistent with an honest purpose to deal fairly with any creditors the debtor then had, or might thereafter have in the ordinary course of his business, and that neither the conveyance to the wife nor the withdrawal of the husband's means from his business for the purpose of improving the land settled upon the wife had the effect to hinder or defraud his then existing or subsequent creditors. In Pepper v. Carter, the Supreme Court of Missouri said, "Some would make an indebtedness per se evidence of fraud against existing creditors. Others would leave every conveyance of the kind to be judged by its own circumstances, and from them infer the existence or non-existence of fraud in each particular transaction. Without determining the question as to existing creditors, we may safely affirm that all the cases will warrant the opinion that a voluntary conveyance as to subsequent creditors, although the party be embarrassed at the time of its execution, is not fraudulent per se as to them. But the fact, whether it is fraudulent or not, is to be determined from all the circumstances. I do not say that the fact of indebtedness is not to weigh in the consideration of the question of fraud in such cases, but that it is not conclusive. The language of this case is quoted approvingly by the same court in the later case of Payne v. Stanton, where it is said, "The doctrine is well settled that a voluntary conveyance by a person in debt is not, as to subsequent creditors, fraudulent per se. To make it fraudulent as to subsequent creditors, there must be proof of actual or intentional fraud. As to creditors existing at the time, if the effect and operation of the conveyance are to hinder or defraud them, it may, as to them, be justly regarded as invalid, but no such reason can be urged in behalf of those who become creditors afterwards." These cases in Missouri are quoted from at length and declared to be controlling by the United States Supreme Court in Wallace v. Penfield, U by Supra. In the latter case, however, the facts proved and found by the court expressly repel the idea that the debtor was embarrassed or insolvent when the settlement was made, and the decision can scarcely be regarded as fully approving Payne v. Stanton in similar cases to the effect that an embarrassed debtor may make a voluntary conveyance which will be upheld against subsequent creditors. These Missouri cases are at least dangerously near the border line. The court in Payne v. Stanton draws the distinction between existing and subsequent creditors, and says that the conveyance might hinder, delay, and defraud the former, but no such reason can be urged in behalf of those who become creditors afterwards. This, we respectfully urge, is attaching undue importance to the exact date or period of time when the creditor's claim accrued. The embarrassed debtor, under this rule, might voluntarily alienate the mass of his property, then secure loans or incur obligations to creditors, whose claims would thus be subsequent to the voluntary conveyance, and with the money thus acquired liquidate the obligations existing when the conveyance was effected. The embarrassment of the debtor when the transfer was made calls into being the claims of, and obligations to, the new creditors, the deficit that existed, and the liability has been merely transferred to new parties, while the debtor's embarrassed estate has been further crippled or rendered hopelessly insolvent by the voluntary alienation. It seems to follow that the safer and more prudent rule would be to hold that no voluntary conveyance by an embarrassed debtor should be upheld against creditors, whether their claims accrued prior or subsequent to the transfer. SS 100. Placing property beyond the risk of new ventures or speculations. This brings us to the most important branch of the subject, viz., the effect of conveyances, gifts, and settlements made to avoid the risks of losses likely to result from new business schemes. To illustrate, a baker who had been carrying on business for some years being about to purchase a grocery business, which he intended to carry on together with his own trade, made a voluntary settlement of nearly the whole of his property upon his wife and children. He then purchased the grocery business, and having lost money sold it, but continued in business as a baker. 3 years after the settlement he filed a liquidation petition. The court held that independently of the question whether he was solvent at the date of the settlement, it was voidable as against the trustee in liquidation. Under the Stat. 13 Aliz. C5, on the ground that it was evidently executed with the view of putting the settler's property out of the reach of his creditors in case he should fail in the speculation on which he was about to enter, and carrying on a new business of which he knew nothing. If a settlement is made on the eve of a new business, and with a view of providing against its contingencies, it is as unavailing against new creditors as against old ones. This same general principle was involved in Case v. Phelps in the New York Court of Appeals. Woodruff, J., a judge of much learning and great vigor of mind, said, "May a person about to engage in business which he believes may involve losses, with a view to entering upon such business, convey his property to his wife, voluntarily, without consideration, to secure it for the benefit of himself and family, in the event that such losses should occur? I cannot regard this question as in substance, other than the inquiry, may a man, for the purpose of preventing his future creditors from collecting their demands out of his property then owned, and for the purpose of casting upon them the hazards of his success in the business in which he is about to engage, convey his property without consideration to his wife, in order to secure the benefit of it to himself and family, however disastrous such business may prove, and continue in the possession, not even putting the deeds upon record, until after such subsequent indebtedness arises. The question of the validity of a gift or settlement as to subsequent creditors, as we have said, turns upon the question as to whether it was made in contemplation of future debts, or to secure the debtor a retreat in the event of a probable pecuniary disaster in a hazardous business in which he proposed to embark. To bring the transfer within this rule, it must be executed with the intention and design to defraud those who should thereafter become his creditors. The debtor proposing to throw the hazards of the business in which he is about to engage upon others, instead of honestly holding his means subject to the chance of the adverse results incident to all business enterprises. But these cases must be considered within proper restrictions. Thus, where a man who is solvent paid for property which he procured to be conveyed to his wife, and there was no evidence tending to show that by so doing he intended to defraud any subsequent creditors, it has been held that the conveyance is perfectly valid in her favor as against his subsequent creditors, and that a husband had a right to make a settlement of property upon his wife, provided it was free from fraud. Subsequent indebtedness cannot be invoked to make that fraudulent which was honest and free from impeachment at the time. In Graham v. Railroad Co., a leading and important case, it is said to be a well-settled rule of law that if an individual, being solvent at the time, without any actual intent to defraud creditors, disposes of property for an inadequate consideration, or even makes a voluntary conveyance of it, subsequent creditors cannot question the transaction. The argument advanced is that such creditors are not injured. They gave credit to the debtor in the status which he had after the voluntary conveyance was made. This rule was applied to an alienation by a corporation. SS 101. Conveyances avoided. The Chancellor said in Beekman v. Montgomery, aside from the fact that the deed was made by the father in contemplation of future indebtedness, there are strong circumstances indicating the existence of actual fraud. The deed was made on the eve of the grantor engaging in mercantile business, which would require for its successful pursuit both capital and credit. He disposed, at the time of the conveyance, of the entire control of his real estate, which constituted the bulk of his property, leaving himself in inadequate capital for conducting his business or raising loans. The credit which he obtained was due to his former standing as a man of responsibility. The conveyances to his children were not advancements adapted to the means and situation in life of the grantor. They absorbed his whole property. The deed to the defendant was made while he was an infant but 16 years of age, not needing an advancement, and not of discretion to take charge and management of the property. It was kept secret for more than a year, and was not left at the office to be recorded till the day after a suit at law was commenced by the complainants for the recovery of their debt. If a person about to contract debts makes a voluntary conveyance, with the intent to deprive future creditors of the means of enforcing collection of their debts, and this purpose is accomplished, it is very clear that such creditors are injured and defrauded. A creditor has a right when extending credit to rely upon the honesty and good faith of the debtor, and may assume, without inquiry, that the debtor has made no fraudulent conveyances of property. SS 102. Conveyances not considered fraudulent, but the courts will not willingly overturn a settlement or voluntary alienation at the suit of the subsequent creditor, upon slight, unsubstantial, or intangible proof. Carr v. Brees is an illustration. In that case, the New York Court of Appeals, overruling the court below, decided that where a husband, worth $22,000 owing debts amounting to $2,800 which were subsequently paid, and engaged in a prosperous business, purchased property costing about $16,000 and took it in the name of his wife, and paid about $10,000 of the consideration by mortgage on his real estate, and the balance by mortgage upon the premises purchased, the settlement was not unsuitable or disproportionate to his means. Miller, J., speaking for the court, said there was no insolvency in fact or in contemplation, no new enterprise started which involved unusual or extraordinary hazard, but the continuance of the business of the grantor for the period of 3 years, and no dishonest failure or attempt in any form to defraud. An existing indebtedness alone does not render a voluntary conveyance absolutely fraudulent and void as against creditors, unless there is an intent to defraud. This is especially the case when it is shown that the residue of the property was amply sufficient to pay all debts. It may be observed that although in Babcock v. Eckler the disproportion was far greater than in Carr v. Brees, the conveyance was upheld, but in this case evidence was introduced tending to show that the conveyance was not entirely voluntary. Again in Carpenter v. Rowe, the court, citing Hens Lessee v. Longworth, say, if it can be shown that the grantor was in prosperous circumstances and unembarrassed, and that the gift was a reasonable provision, according to his state and condition in life, and leaving enough for the payment of the debts of the grantor, the presumptive evidence of fraud would be met and repelled. SS 103. Subrogation of subsequent creditors. A device to which fraudulent insolvents often resort consists in making a voluntary conveyance and following this up by paying all the antecedent or existing creditors, practically with the monies derived from the credit extended by subsequent creditors. Savage v. Murphy, already quoted, was such a case. It is a most unsubstantial mode of paying a debt to contract another of equal amount. It is the merest fallacy to call such an act getting out of debt, and the case should be treated as if the prior indebtedness had continued throughout. SS 104. Subsequent creditors sharing with antecedent creditors. In a case which arose in Massachusetts, in which an administrator sought to annul a fraudulent alienation made by his intestate, Dewey J. said, though the ground of avoiding this conveyance is that the land was liable to be taken to satisfy existing creditors only, yet when the conveyance is avoided, the proceeds of the sale will be assets generally, and other creditors will receive the benefit thereof incidentally. In Kerr v. Smith, Davis, J. observed, it is well settled, where a deed is set aside as void as to existing creditors, that all the creditors, prior and subsequent, share in the fund pro rata. Mr. Peachy observes, it has, however, never been disputed but that a subsequent creditor will participate in the benefit of a decree instituted by a prior creditor, and would have the same equity for having the property applied. Again, no distinction has been drawn in such cases between the different classes of creditors, that is, between those whose debts existed at the time the deed was executed, and those who became creditors subsequently, or that any priority can be given to those who were creditors at the date of the instrument over the subsequent creditors. All would, in fact, participate pro rata. There has been, however, some hesitancy on the part of the courts in holding that a deed which existing creditors could avoid was, after avoidance by them, to be considered void as to all creditors, for that is practically the effect of letting in subsequent creditors, especially to share pro rata. Though the deed cannot be set aside at the instance of subsequent creditors, yet the authorities seem to give them the same benefit when the antecedent creditors succeed in annulling it. It would seem to result that while there is a discrimination in the right to attack the conveyance, there is none as to sharing in the successful result. In considering this feature, however, the rule that a creditor, by filing a bill, acquires an equitable lien and preference in certain cases, must not be overlooked. SS 105. Mixed claims accruing prior and subsequent to alienation. The right of a grantee or vendee from whom a creditor seeks to wrest property held in trust for a debtor, to require the creditor to show, in a proper case, that his debt accrued before the conveyance which is questioned, is clearly established, as a voluntary or fraudulent conveyance is ordinarily good between the parties, and can be upheld except as against certain classes of persons. It follows that the vendee can force the plaintiff to show that he comes within some privileged class entitled to impeach the transaction, where it is important or vital to the creditor's success to show that he was an existing creditor as to the conveyance, and it appears that some of the items of his claims accrued prior and others subsequent to the conveyance, and all these items are embodied in one judgment. It has been held in several cases that he is to be treated as a subsequent creditor, not entitled to attack the conveyance. In Baker v. Gilman, the creditor was an attorney and his claim was for services. Johnson, J., said the plaintiff was clearly a subsequent creditor of Gilman. His employment, by virtue of his retainer, was a continuous one until the determination of the actions. It was a single demand for services, a small portion of which were rendered before the conveyance, and the far larger portion long afterwards. This being embraced in one judgment, nearly 2 years after the conveyance, renders the plaintiff clearly a subsequent creditor. In Reed v. Woodman, it appeared from the evidence that the greater part of the debt which was the foundation of the judgment rendered in favor of the demandant accrued subsequent to the date of the challenged conveyance. The court said the levy was entire and cannot be so apportioned or divided as to constitute a satisfaction for that part of his debt which was due prior to that deed. The demandant, having taken judgment for his whole demand, is to be regarded as a creditor subsequent to the conveyance of the land in question by his debtor. He cannot therefore impeach that conveyance but by showing actual fraud. SS 106. Status of creditors whose claims accrued after notice of alienation. As a general rule, a subsequent creditor who acquired his claim with knowledge or notice of the conveyance sought to be annulled cannot attack it as fraudulent. In Baker v. Gilman, Johnson, J., said, I do not think a creditor who has trusted his debtor after being fully informed by the latter that he has put his property out of his hands by a conveyance, valid as between him and his grantee, though voidable as to existing creditors, should ever be allowed to come into court and claim that such conveyance was fraudulent and void as to him on account of such indebtedness. As to such creditor, a conveyance of that kind would not be fraudulent in any sense and could not, on that ground, be avoided.